Assalamu alaikum. Welcome back to our channel. We are once again opening up the book True Courtroom Stories, researched by Mr. Zahir Ahmad Mir. And today we're doing a really deep dive into episode 99. This one, well, it tackles what might be the single most challenging, most volatile question in governance and ethics. Where exactly does the sacred right of freedom of expression end, and where does dangerous, harmful action begin?
It's the line everyone is trying to find.
Exactly. And our mission today is pretty comprehensive. We're going to dive into the foundational Islamic ethics of speech that the source lays out. Then we'll use a specific case narrative from Mr. Mir's research as our anchor. And from there, we'll connect that ruling to these huge global constitutional precedents, like Brandenburg v. Ohio in the U.S., and the framework of Pakistan's Article 19. We're really looking for that common thread. What defines the breaking point?
And the sources we're looking at, they don't treat this as some abstract philosophical exercise. They treat expression as a fundamental power that absolutely demands responsibility. It's a live wire, as you said. I mean, on one hand, speech is the vehicle for truth, for political change, for dissent. It's the cornerstone of any free society.
Right.
But on the other hand, it can mobilize hate, fear, and violence on a massive scale.
Right.
So this deep dive is all about defining, both legally and ethically, that precise, fact-specific moment when expression forfeits its protection and becomes a prosecutable crime.
That distinction, when expression stops being an idea and becomes an action, that's the challenge. It's what judges and lawmakers have been wrestling with for centuries. So we're not just looking at what the rules are, we're trying to get at the philosophical why behind them. Okay, let's unpack this. Let's start right at the beginning with the ethical framework that the source material presents. So this Islamic ethical framework, it offers a really different starting point from a lot of modern Western views. Instead of saying expression is an inherent absolute license, a right you just have, it describes speech as an amana, a sacred trust. Why is that conceptual difference so important? What kind of accountability does it create right from the start?
Well, it's a complete repositioning of the burden, really. If you think of speech as an absolute license, then the speaker's main concern is their own right to speak. And the burden is then heavily on the state or anyone else to justify why they should be restricted. The focus is on the holder of the right.
Right. It's my right. You have to prove I can't use it.
Exactly. But when you frame speech as an amana, as a trust, the entire dynamic shifts. It shifts toward stewardship. The speaker is seen as a temporary guardian of this incredibly powerful tool language, which has community-wide consequences.
A guardian, that's a powerful word.
It is, because it instantly implies accountability. You're responsible not just for the act of speaking, but for the moral quality, the truthfulness, and crucially, the foreseeable consequences of what you say. It's an ethical principle that comes before any legal code. It's like an internalized moral compass that says, you have this power, now use it constructively.
That sounds incredibly challenging, especially in a modern, pluralistic society. If speech is a trust, isn't there a huge risk that whoever is in power or whoever gets to define societal morality, couldn't they just exploit that definition to say what breaches the trust, to effectively silence any criticism they don't like?
And that is the essential tension. Absolutely. It's why the legal systems that are built on this ethical foundation, they require such meticulous rules and judicial oversight. The restraints can't just be about someone being offended. They have to be specific and tied to observable, tangible harm. And the source material actually outlines 4 primary areas where this trust is legally considered breached. This is where it moves from the abstract principle to, actionable wrongs. Incitement, slander, chaos, and violence. These are the specific, defined limits.
Let's get into those practical restraints then. Let's start with the 2 that seem most related to social cohesion, slander and chaos.
Absolutely. So let's take slander or defamation. In this ethical system, protecting a person's reputation and honor is paramount. It's considered an inviolable right, right up there with the right to life and property.
So it's not just about hurt feelings.
Not at all. The legal prohibition against slander is so intense because the irresponsible use of speech to spread lies, it destroys social capital. It destroys individual dignity. In classical jurisprudence, you often see this linked to the law of cutoff, which deals specifically with false accusations of a very serious nature. And the severity of the punishment for making a false accusation really highlights how serious the misuse of this trust of speech is considered.
So it's not enough to just say, oops, my mistake, and apologize.
No, because you've fundamentally undermined the integrity of the community. You've poisoned the well of reliable information. To prove an accusation in that system, you often have to produce multiple witnesses. which, again, just emphasizes the community's stake in the truthfulness of what people say. The law here is protecting the stability of relationships against the destructive power of a malicious tongue.
That's a really powerful connection. It grounds defamation in protecting the whole society, not just one person's ego. Okay, now let's move to that second limit you mentioned. Chaos. The duty to avoid disruption and maintain public order. How does that ethical restraint define the line between, say, a protected protest and prohibited societal destabilization?
This is often discussed in terms of preventing fitna.
Fitna.
Yes, and it's a concept that's broader than just political unrest. It means something more like sedition, discord, or the deliberate manufacturing of widespread societal chaos and moral confusion. The framework recognizes that certain types of speech are designed purely to shatter the collective peace, the maslaha.
So how do you tell the difference? I mean, a passionate protest could look like chaos to some people.
It's about intent and purpose. Protected protest, even if it's angry or highly critical of the government, is ultimately aimed at persuading change within the system. Speech that aims for chaos, for fitna, is designed to tear down the system itself through non-legitimate means. It often works by exploiting existing tensions or spreading known falsehoods just to cause panic.
Can you give an example?
Sure. Criticizing government policies on, say, food prices is protected dissent. But spreading a completely fabricated rumor that a neighboring community is stockpiling weapons and is about to attack solely to incite a riot and intercommunal violence.
That breaches the trust.
It breaches the trust because its only intent is pure destabilization and panic. The duty is to use speech to improve society, not to deliberately dismantle it.
So what this ethical system is recognizing, it sounds like, is that even if there isn't an immediate physical punch thrown, the deliberate breakdown of civil understanding through manufactured fear is, in itself, an act of aggression against the society.
Precisely. It's a proactive measure against social dissolution. And that brings us to the two most direct restraints. Incitement and violence. Incitement is the active promotion or urging of illegal or harmful actions. Violence, while that's the direct use of words, is the precursor or the actual instrument for physical harm.
So the protection from the amana, from this trust, it's just immediately withdrawn the moment a speaker uses words to actively mobilize people toward a physical crime. The words stop being an argument and start being, what, an instruction manual or a trigger?
Exactly. A trigger is a great word for it. When the speaker's intent and the probable outcome are directed toward illegal physical injury or destruction, the trust is comprehensively betrayed. And this profound philosophical understanding that your freedom is inextricably linked to your responsibility, that is the backdrop against which any judge has to operate when they're faced with a public orator who is pushing those boundaries.
You know, it really does give us that moral compass we need, especially now. We're just saturated with information, and so much of it is designed to maximize clicks, outrage, disruption. Understanding that your right to speak comes with an inherent responsibility to the truth and to the community, that it's a trust that really changes how you assess every headline, every public statement you hear.
Okay, so now we move from that ethical ideal to the legal reality in a courtroom. And we're drawing directly from the narrative detailed in episode 99 of the book True Courtroom Stories, researched by Mr. Zahir Ahmadmir. This case, the case of the inflaming orator, is just so vital because it shows us exactly how a judge put these concepts of speech limits into practice.
It's a textbook example.
Yeah.
The scenario that Mr. Mir's narrative presents it's a perfect case study of that line being crossed. You have this orator, a very passionate speaker known for drawing huge crowds, and their rhetoric is focused on a specific, deeply divisive public issue. They're holding these rallies in a public square, and while they start with just fiery political critique, the speeches begin to escalate. Okay, so what were the specific actions? What were the words that moved the orator's speech from what would be protected, passionate critique into unlawful incitement? We need the color from the story here.
The transition was really marked by three key elements that the judge ended up focusing on. First, the speaker stopped talking about policy and started talking about people, individuals.
Groups.
Okay, personalization.
Yes.
Second, the rhetoric shifted from the general, like something should be done about this, to the specific command, you must do this now. And then, most critically, the orator started directing the crowd to a specific location, a public building, an institution associated with their grievance. And they either implied or directly stated that the crowd should go there and confront authorities or take physical action. Immediately. Right after leaving the rally.
So the speech wasn't just expressing outrage anymore.
No. It was serving as the countdown clock for a crime.
Okay, so you can just imagine the courtroom. The defense argues, my client was just expressing political dissatisfaction. It's a fundamental right. And this prosecution argues, no, your client was directing a mob to commit a crime. Okay. What was the judicial maneuver? How did the judge distinguish between protected dissent and prohibited action?
The judge's entire ruling hinged on two concepts: intent and imminence. The judge explicitly acknowledged the absolute right to criticize. They even said that the right to criticize the government has to be protected no matter how harsh or uncomfortable that criticism is.
That's the protected zone.
That is the protected realm of lawful criticism. However, they ruled that the moment the orator tried to move that crowd from a state of passionate hearing to a state of immediate directed action, the moment the words became a call for physical violence that was likely to happen in the next few minutes or hours,
The protection just evaporated.
it vanished. The words had stopped being advocacy and had been transformed into an instrument of harm.
And according to the source, what was the key phrase? The legal threshold.
The phrase was definitive. Speech causing imminent harm loses protection. That temporal element, imminence, that is the cornerstone of the whole decision. It's the difference between saying, this system is unjust and must be overthrown someday, and saying, let's all go overthrow that building right now.
I see.
The judge was looking for hard evidence that the order was trying to create an unavoidable, immediate physical consequence and using the crowd as their weapon to do it.
The high stakes in making that assessment must be just enormous for a judge. They're not just reading a transcript after the fact. They have to evaluate the specific context, the mood of the crowd, the volatility of the location, and whether that orator had actually established enough authority over the audience to compel them to immediate lawless action.
Exactly. Judicial assessment of incitement is one of the most context-heavy tasks in all of law. The judge has to rule on the likelihood of the harm. I mean, if the orator was screaming these same commands to an empty room or to a crowd that was just sitting there passively laughing at him,
Then the element of likelihood is missing.
It's missing. And the speech might remain protected no matter how vile the intent was. But if the evidence shows a volatile, agitated crowd, and the orator specifically intended to channel that energy into immediate violence, then the words are deemed causative. The speaker is held accountable for the consequence, just as if they had physically thrown the first rock themselves. The words were the delivery mechanism for the crime.
so that local judgment, rooted in this ethical tradition, it perfectly set that threshold of imminent harm. And what's so fascinating now is to see how this specific ruling mirrors, or in some cases diverges from, these established constitutional standards all around the world. It's the perfect pivot point for our comparative legal analysis.
It is. The transition from a specific regional courtroom decision to global constitutional law is critical because it reveals a universal struggle. Every stable legal system has to manage the volatility of political speech. They might use different language, different tests, but they are all trying to define that exact moment when expression becomes action.
So we can now take that specific finding, the imminent harm test that the judge applied in the case, and see how it stacks up against established constitutional standards. And it shows that the judge's logic, which was informed by that ethical principle of speech as a trust, it actually finds a very strong resonance in modern, secular, and diverse constitutional structures.
Let's start with the U.S. parallel, which the source material specifically references the Brandenburg test. This comes from the 1969 Supreme Court case Brandenburg v. Ohio. It's basically the definitive standard in U.S. law for restricting political speech. So what is the fundamental requirement for restriction under Brandenburg?
The Brandenburg test established an exceptionally high bar. It confirmed that speech is protected unless it satisfies a very strict two-pronged test. 1. The advocacy is directed to inciting or producing imminent lawless action. And 2, the advocacy is likely to incite or produce such action. If the state fails to prove either one of those, either the intent or the likelihood, the speech remains constitutionally protected.
It's really vital to put Brandenburg into its historical context because it replaced an older, much less protective standard, didn't it? This change, it reflects a pretty fundamental shift in how the state views political dissent.
Oh, absolutely. Brandenburg effectively overturned the much looser and frankly more repressive standards that had been in use for decades. Things like the clear and present danger test, which came from the Schenck case back in 1919, or even the bad tendency test.
And under those older standards.
Under those older standards, speech could be restricted if it merely tended to lead to illegal activity at some vague point in the future. This gave the government immense latitude, especially during periods of national tension, the Red Scare, McCarthyism,
To prosecute critics.
to prosecute critics simply because their ideas were unsettling or seemed dangerous to the established order.
So Brandenburg radically tightened that definition. The danger has to be not just clear, but imminent. It has to be about to happen and lawless. That's a huge philosophical decision for a court to make.
It is. And it embodies this deep skepticism in the U.S. constitutional tradition about the government's ability to define good or safe speech. The underlying principle is that in the marketplace of ideas, even robust, maybe hateful, speech should be allowed to circulate. The trust is that the public will ultimately reject the falsehoods. In that view, the government trying to regulate ideas is seen as the real danger, not the dissenting speaker.
So how does this two-part Brandenburg test directed intent and likelihood, how does that compare to the judge's ruling we just discussed in the Orator case where the standard was speech causing imminent harm?
The Orator case ruling is almost a perfect practical application of the Brandenburg principle. When the judge in the source material was looking for that transition from protected criticism to unlawful incitement, they were implicitly applying both prongs of the test.
Okay, break that down.
Well, first, they looked at intent. Was the orator directing the crowd to do something? The evidence showed, yes, he specifically targeted a building and gave instructions. That's the first prong. Second, they looked at likelihood and imminence. Was the harm about to happen? Was the crowd primed and ready to act? The evidence suggested yes. So the high bar for restriction was met.
So it's a powerful convergence of legal thinking, even across different systems.
An incredibly powerful convergence. When you're talking about restricting political advocacy, the bar has to be set at the threshold of immediate physical action. Otherwise, the state can just too easily silence any unpopular opinion. That imminence requirement is what protects the right to radical advocacy. You can argue for revolution in the abstract, but you cannot organize and initiate a riot in the here and now.
That emphasis on imminence, that's what provides the breathing room for a democracy to function. It ensures that the government has to tolerate profound, often really uncomfortable criticism right up until the point where the physical safety of citizens or core infrastructure is threatened right now.
Exactly. The test is designed to be difficult to meet. It reserves punishment for those instances where the words are essentially part of the execution of a crime. It treats the speaker as an accomplice or an instigator of immediate violence.
Okay, so now that we've established that very high bar of imminence in both the U.S. context and the Orator case, let's pivot. Let's look at a system that explicitly uses a broader set of predefined categories for restriction, which brings us right back to the environment of the source material.
Right, so we turn now to Pakistan's constitutional guarantee of freedom of speech and expression, which is found in Article 19. And this article balances the right with a framework of reasonable restrictions. It's a profoundly different legal mechanism from the near absolute right model of the U.S.
Can you explain that difference in mechanism? Under Article 19, the right to free expression is granted, but it's simultaneously conditioned. What does that actually mean for the average speaker?
It means the right is never conceived of as limitless from the start. It's constitutionally guaranteed, yes, but the Constitution itself explicitly states that this guarantee is subject to laws that impose reasonable restrictions. The Constitution grants the state the power to limit speech in specific predefined areas.
And you see that in a lot of countries.
You do.
Mm-hmm.
And it's often the case in countries whose constitutions are designed not just to limit the power of the state, but also to actively define the characteristics of a moral, orderly society. The whole constitutional structure assumes that speech must operate within bounds that protect the foundational values and the stability of the nation. And those specific categories of reasonable restrictions that are detailed in the source material, public order, morality, and state security, they become the judicial measuring sticks.
Let's analyze these specific categories, because this is where the philosophical contrast with Brandenburg gets really sharp. Let's start with public order.
Okay. Public order aligns somewhat with the Orator case, but it's typically a much broader category than just imminent lawless action. It aims to prevent large-scale disruption, unrest, or chaos that compromises the everyday safety and functioning of public life.
So it's not just about preventing a riot right now.
Exactly. For example, while organizing a peaceful protest is protected, organizing a massive disruptive blockade of critical infrastructure, like a highway or a port, could fall under a restriction on public order, even if the violence isn't strictly imminent. The focus is on preventing significant civic disruption or facade.
And then we come to the category of morality. This is where the judicial difficulty must just escalate because morality is notoriously subjective. How does a court even begin to interpret reasonable restrictions that are based on morality?
This is arguably the most sensitive restriction, and it highlights the core philosophical difference we're talking about. It explicitly allows the state to restrict speech that is deemed offensive or contrary to the established societal standards of decency and ethics. And because Pakistan's legal system is informed by Islamic jurisprudence, which ties right back to that ethical concept of speech as a trust, there's a constitutional mandate to protect core social values.
But the difficulty, as you said, is definition.
It is. Courts are constantly wrestling with what constitutes morality in a diverse modern context. Is it the lowest common denominator, the highest ethical standard? Whose morality? The judicial task becomes one of balancing an individual's right to artistic expression or commentary against the community's right to maintain its defined moral character. Legal challenges often come up when defining obscenity or when interpreting speech that critiques or ridicules deeply held religious or ethical beliefs. The state has the constitutional backing under Article 19 to intervene to prevent what it deems a breach of public moral standards.
So, the philosophical difference here is profound. The U.S. constitutional model is deeply skeptical of the government's ability to define what is moral or good speech. It prefers to let the individual define their own terms and only intervenes when physical harm is imminent. But Article 19, it grants the state explicit authority to preserve the social and ethical character of the nation, right alongside physical security.
Exactly. The U.S. prioritizes the untrammeled process of speech, focusing on political effectiveness and physical safety. The Pakistani system, informed by that ethical concept of amana, incorporates the protection of communal values into the constitutional mandate itself. So the line is drawn not just by temporal immediacy, but also by the categorical violation of these defined social interests. This means that under Article 19, speech can potentially be restricted, not because it's going to cause a riot right now, but because it's deemed fundamentally destabilizing to the moral fabric of society. And that's a concept that is entirely foreign to the Brandenburg Standard.
And the final major restriction category, state security.
This one is pretty common across most global constitutions. It permits the state to restrict speech that directly threatens the integrity, defense, or sovereignty of the nation. So this would include things like sharing military secrets, advocating for the violent overthrow of the state, or inciting espionage. The legal challenge here, as always, is ensuring that this restriction isn't abused to silence legitimate political opposition, that the speech genuinely threatens national security and isn't just embarrassing the government.
This whole comparative analysis, it shows that while both systems value free speech, they approach the necessary limitations using entirely different tool sets. One uses the very high bar of imminence as a singular exception. The other uses a framework of reasonableness applied across these predefined categories like morality and public order. But at the end of the day, they both land on the understanding that the right is conditional.
And that conditionality is ultimately tied to responsibility. Whether the standard is the American judicial doctrine or the ethical standard from the source material, the moment the speaker acts without responsibility for the consequence, their protection falters. So we've completed this deep dive into the three critical layers. We have the ethical foundation of honor, we have the judicial application of imminent harm in the orator case, and we have the constitutional balancing acts of Brandenburg and Article 19. It's time now, I think, to distill the ultimate principle that binds all of these systems together.
And the source material provides that core principle, the ratio decidendi, the core reason for the judgment itself, which perfectly synthesizes this entire journey. And it is. Speech is free until it becomes a weapon.
That phrase is just a masterpiece of legal and ethical summation. It's so powerful. It moves the entire conversation away from abstract rights and into functional consequences. The key differentiation lies in intent and function. If the speech's primary function is communication, criticism, debate, even passionate persuasion, it's protected. But if the speaker changes the function and weaponizes their words, using them as a tool to execute a crime, to compel immediate unlawful action, or to deliberately manufacture chaos, the legal protection vanishes. Yeah. Because the trust has been explicitly violated.
Let's elaborate on that weapon analogy. How do we legally and ethically differentiate communication from a weapon?
A weapon is characterized by its destructive intent and its direct capacity to inflict harm. So if an orator gives a speech detailing their hatred of a political party, that's communication. It might be offensive, divisive, it might even lead to long-term political instability, but it remains protected expression aimed at persuasion or change. But if that same orator hands out rocks, points to a specific individual in the crowd, and screams, "Attack him now before he leaves this room," the words are no longer communication. They have become the immediate instrumental trigger for a physical assault. They are the weapon. The judge in the case narrative had to find proof of that immediate shift from idea to instrument, and that distinction is the bedrock of freedom. We punish the use of the weapon, not the dislike of the idea.
This inherent limitation, which we see applied so consistently across the globe, it just reinforces this idea that all rights, even the most fundamental ones, are contextual, they're relational. Your right to speak is contingent upon your respect for the fundamental rights of others to safety, security, and reputation.
Absolutely. And this responsibility is so powerfully reinforced by the moral lesson that the source material provides, which is words build nations and can burn them. And that isn't just a nice metaphor, it's a recognition of the constitutive power of language.
Words are the very building blocks of our entire world. Our legal world, our social world, our contractual world. We use them to establish common ground, to define justice, to create shared aspirations. But that immense constructive power, it carries the inverse potential. A carefully crafted statement can establish peace, while an equally carefully crafted piece of propaganda can initiate a genocide.
The lesson is that freedom of speech is not the absence of limits, it is the presence of profound responsibility. The ethical duty to ensure your words are constructive, truthful, and non-harmful has to come before the constitutional inquiry into whether they are legal. The orator we discussed learned that the hard way. The power of his rhetoric was celebrated when he used it for advocacy, but it was condemned when he deployed it as an instrument of immediate violence and chaos. The responsibility is inherent in the power itself.
So, if we synthesize this entire deep dive, the lesson is that every legal system, whether it's based on the high bar of imminence or the framework of reasonable restrictions, is ultimately trying to hold the speaker accountable for the consequences of their words. So what does this all mean? The critical lesson we've extracted from our in-depth analysis of episode 99 of the book True Courtroom Stories, researched by Mr. Zahir Ahmad Mir, is this. There is a universal human consensus that expression, however fundamental, must yield when it directly and immediately jeopardizes the physical safety and the fundamental social order of the community.
And this demands constant vigilance from you, the listener. As you consume the endless flow of information, you have to constantly evaluate the intent and the likely consequence of the speaker's words. Are they offering protected, necessary criticism aimed at improving the system through debate? Or are they attempting to bypass the democratic or ethical process entirely by manufacturing a weapon, by directing or making highly likely immediate unlawful physical action? That is the essential assessment, separating robust advocacy from calculated incitement. And these legal systems demonstrate that while they may define the boundaries differently, using imminent lawless action as the test for physical harm, or reasonableness as the test for social and moral harm, the core human responsibility for the consequences of one's words remains paramount. It's universal. The source material proves that rights are conditional upon their responsible use.
So if the moral lesson that binds all these legal frameworks together is that words build nations, then every single one of us who speaks, who writes, who tweets, possesses an immense nation-shaping power. And we have to ask ourselves the most provocative thought of all. Are we honoring the trust that is inherent in our freedom to speak? What kind of nation are your words building today? Thank you for joining us on this extensive deep dive into the ethical and constitutional boundaries of expression. We hope this is giving you a clearer, more nuanced understanding of the profound responsibility that is the cost of the right to speak freely. Until next time.